Hello everyone, my name is Professor Luke Nottage from the University of Sydney. I'm pleased to present along with my colleagues Dr. Anna Ubilava, also from the University of Sydney, and Professor James Claxton from Waseda University in Tokyo. We're going to talk about the investment chapter potentially of the Australia-India Free Trade Agreement by considering especially the possibility of introducing mandatory investor-state conciliation before arbitration in such Asia-Pacific treaties. So the background to this paper is that in 2015 to 16, India introduced a new, more pro-host state model bilateral investment treaty, or BIT, following an investor-state ISDS arbitration in favour of white industries in 2011. And this led to termination of various Indian BITs, including the one with Australia dating back to 2000 that generated the white industries claim successfully against India in 2011. And this new model BIT is being used also for India to propose in ongoing treaty negotiations. But we've seen that in 2020, India was not able to join the 15 other states, including Australia, in the Regional Comprehensive Economic Partnership, RCEP, FTA, and it might also be a stumbling block, this investment model that India is promoting in the ongoing Australia-India FTA negotiations. So perhaps, just like Australia agreed to have a new form of procedure to resolve investment disputes in the investment chapter with Indonesia in its FTA in 2019, this could be a way forward for the Australia-India FTA negotiations and drafting. So that's my overview. Let me turn to a closer look at what's happened in India. So basically, from the 1990s in particular, India liberalized its economy, welcomed foreign investment, sought to encourage more inbound FDI by signing a number of investment treaties, usually standalone bilateral investment treaties, even in recent years, rather than investment chapters within free trade agreements. But this has led to eventually, from 2010, an increase in inbound investor-state arbitration claims because the investor-state ISDS provisions were added to make more credible the liberalisation and protection commitments made by India to encourage inbound FDI through treaties. So specifically, the first in this line was actually started as just a commercial arbitration between white industries, an Australian resource company, and an Indian coal state-owned enterprise that led to the arbitral tribunal giving an award in an ICC arbitration for only 4 million Australian dollars. But the Australian investor had huge difficulties trying to enforce this $4 million award against the Indian company in the Indian courts. And so then they turned to the 2000 BIT between Australia and India, and through the most favoured nation commitment in that treaty, we're able to refer also to commitment made by India under its BIT with Kuwait to provide effective means for enforcing commercial arbitration awards. So the tribunal in the white industries case ended up awarding in 2011 a total of now $10 million Australian in favour of white industries, but through this new ISDS arbitration under the then BIT between Australia and India. So rather than the SOE paying $4 million, the Indian government in international law through this treaty had to pay $10 million. And in addition, the tribunal ordered each party to share equally in other costs of this new ISDS arbitration under the treaty. In fact, and these were quite large amounts, $1 million for the claimant law firm fees. So they had to bear that cost out of their $10 million award. And in the Indian case, they paid 13 million rupees plus almost £500 million in legal fees to their own lawyers to unsuccessfully defend the case. So we can see here running these international arbitrations is not cheap and takes some time. Since then, there have been 17 other known ISDS claims brought against India. 4 have been successful, awarded in favour of investors, 1 unsuccessful, so the host state won, India won, and another 1 discontinued, perhaps settled, and the rest are still pending. It's also worth noting that Indian investors outbound are using treaties as well to claim against other countries for discrimination or other interference with their foreign investment based on treaties that promised that the host state won't do things like that. And here we find that there's been already 1 award for investors, but 3 where the states overseas have won. And this is closer to what happens globally with the now universe of over 1,000 known cases, especially since the 1990s, brought under ISDS arbitration. About 1/3 are usually won by the investors. So India's record here with outbound investors starting to use these treaties is a bit closer to that pattern, whereas the inbound claims, India is mostly losing them, which is a bit unusual by world standards. And this is just a list here of the various cases. You can see some are mostly against more unstable countries, more developing countries such as Indonesia, Macedonia, Bosnia, Libya, Saudi Arabia, and Mozambique in recent years since 2014. So these investment treaties cut both ways, and they're being used by outbound Indian investors as well as foreign investors claiming against India of having made their investments and finding them interfered with contrary to what they see as commitments made by India under the treaty. So as I mentioned, against this backdrop, India has come up with a more pro-host state model bilateral investment treaty since 2016 is the final version. It still retains this option of ISDS arbitration, but it's quite a narrow window in terms of first having to exhaust local remedies, trying to get a remedy through Indian courts, even though we know Indian courts are very slow for everyone, not just foreign investors. And then because of a limitation period, they have to also then quickly start their ISDS arbitration after that. Once they get into arbitration, they find that there are narrower substantive liberalisation and protection commitments from the host state. For example, under the new Indian model, there's no most favoured nation commitment, which ratchets up the level of protection based on subsequent treaties entered into by that host state with third states. India has also then terminated many of the older BITs, including the one with Australia that was terminated in 2017, if that's been permitted under those treaties by unilateral notice by India. In other cases where there's no unilateral notification possibility, they're trying to mutually agree changes to those older treaties to make them more, as they see it, pro-host state based on the new model BIT of India. And interesting, I've noticed that Pakistan is recently doing a similar thing. They're trying to develop a model BIT and terminating some of their older BITs that are now seen as too pro-investor from the early days in the 1990s, including also in the backdrop of more inbound ISDS claims. One is actually brought again by an Australian and Canadian conglomerate, Tethyan Copper, which generated a very large award, unusually large award of $5.8 billion US against Pakistan. So similar trends starting to emerge in the neighbouring country of Pakistan. Now, India is also trying to use this model BIT then to negotiate completely new treaties. For example, they tried to use this in relation to Cambodia. But when they come to negotiate with larger economies, like in the ASEAN RCEP or with Australia bilaterally, I think India's new model is likely to be a stumbling block in negotiations. It could be a reason why, in the end, for example, India was not able to reach agreement with the 15 other RCEP signatories. Although RCEP in the end ended up also not including ISDS for now. It's something that's going to be revisited within 2 years of it coming into force. But in the meantime, it doesn't really matter so much, because between the 15 existing signatories, almost all the pairs already have at least one treaty that provides for ISDS to enforce investment commitments. What about Australia? Australia over 2011 to 2013 declared it wouldn't agree to ISDS in future treaties under the centre-left Gillard government. And the backdrop again was quite a high-profile case, the first one against Australia, brought by Philip Morris Asia, challenging Australia's 2010 tobacco plain packaging legislation under an old Hong Kong BIT. That eventually failed, but because background international law found that there was legal forum shopping in that case, but it was a very high-profile case, obviously, and a relatively large claim. So that caused this shift in temporarily in Australian government policy. After the coalition government got back into power from 2014, it reverted to including ISDS in some treaties, but not all, depending on the negotiating dynamics and the particular need for these sorts of provisions. Australia is also renegotiating some older treaties, but on a much slower pace. So, for example, in 2019, they replaced the old Hong Kong BIT when they negotiated in parallel a new free trade agreement for trade in goods and services. They also renegotiated an older Uruguay BIT. They've also managed to retrofit new provisions on pre-2014 treaties potentially by signing up a UN Mauritius Convention. So if counterparty also is a member state of that convention, which is so far quite few member states, but eventually if the counterparty is also signed up to this and ratified this transparency convention, the transparency rules will be expanded around the ISDS arbitration procedures. Australia has also started, although only from 2020, a public consultation to review its older treaties. This hasn't generated a report, let alone a model BIT like we saw emerging from India, and which is common actually in many other countries. Instead, Australia mainly relies on sort of US style treaty drafting as a de facto template for its negotiations, because that's emerged, particularly in the Asia Pacific region, as a sort of a fairly common, widely accepted template. Australia's also been quite reactive and quiet in UNSTRA deliberations about multilateral ISDS reform since 2018. However, Australia has agreed to quite an unusual provision allowing the host state to require an investor to try mediation before ISDS arbitration. This was in the FTA with Indonesia signed in 2019, and we suspect this was probably proposed by Indonesia because it's been pushing for these sorts of initiatives and more mediation of these sorts of disputes in the UN, reform deliberations. And it's also had a lot more inbound claims, including one from an Australian UK investor into a coal mining project in Kalimantan. So it has more interest, I guess, in trying to resolve a dispute through earlier and more cheaply through mediation, rather than seeing it progress to more expensive arbitration. In the same year, 2019, as I said, Australia signed a new BIT with Hong Kong, but that didn't include this mandatory mediation step if requested by the host state before the foreign investor could proceed to investor-state arbitration, even though the contemporaneous Hong Kong UAE BIT had this unusual provision as well. So that's another reason why we think this was proposed from the Indonesian side in the Australia's FTA with that country in 2019. So let's end by having a closer look at investor-state conciliation. Obviously, a major benefit would be that if it works, if you get a settlement by involving a third-party neutral, whose job is to try to get the parties to reach an amicable settlement, you can drastically reduce costs and delays. So just remember how expensive the White Industries in India case was for both sides. And that's because arbitration is becoming increasingly formalized and expensive and lawyer-driven and complicated, like many other sort of dispute resolution processes over the years, especially when us lawyers get involved. And so international bodies such as UNCITRAL, but also the International Centre for Settlement of Investment Disputes and earlier the International Bar Association have been trying to promote investor-state mediation, although so far with relatively little success. It's been provided as an option alongside ISDS arbitration in many of the thousands of treaties now signed worldwide for investment, and yet this conciliation or mediation option is hardly ever chosen. It could be that investors are worried that if they choose the mediation route and there is no settlement, then they're not going to be able to go back or progress to the arbitration route. So therefore they just choose arbitration from the start. Although Dr. Ubilava in her 2021 paper that's forthcoming next year in a US journal that I mentioned on the final slide next, points out that that's shouldn't be the way these treaty provisions are best interpreted, but it's been a possible risk factor leading to a preference for arbitration rather than trying mediation first when in these treaties that provide just the option of either. There's also a possibility that there could be problems enforcing a mediated settlement, whereas there is a framework convention regimes, New York Convention or ICSID Convention, to enforce an arbitral award that comes out of this ISDS arbitration. But now we have the 2018 UN Singapore Convention, even though there's very few ratifications yet, and Australia only joined the 50-odd signatories, including India, as late as 2021. But that should make it easier to enforce any settlement that comes out of investor-state mediation. There's also been some concerns about investor-state mediation generally, such as, for example, that the claimant won't recover as much as from a successful ISDS arbitration, or that it's not suitable if you're seeking non-monetary claims, or that settlements might even promote greater secrecy of outcomes compared to investor-state arbitration, because investor-state arbitration is becoming increasingly transparent. But Dr. Ubilava has done a very detailed empirical analysis of amicable settlement patterns in known investor-state arbitration filings, and found that, in fact, all of those three concerns are not statistically valid. So it bolsters the case to instead try more mediation, because even if this is already not a problem in direct negotiations leading to settlement, if you engage a skilled mediator, it should be even better as a way of quickly and more cheaply resolving investment disputes. So in conclusion, I think Australia, and perhaps especially India, given that it has a lot of inbound claims that are being defended at great cost and so on, both these countries should consider adding a mandatory mediation step in investment disputes in the investment chapter, say, of the Australia-India FTA, and indeed maybe if India does join RCEP and this gets put on the agenda, an investment chapter revision, including ISDS, have this mandatory mediation step before arbitration. But in all cases, states need to be careful and consistent in the wording they start using for this innovation, and also, and for example, the timelines they set, so that this doesn't become an extra source of unnecessary delay in resolving investment disputes. So I hope that was useful for you. On this last slide, there are a series of further readings for you. We actually have an article based on our paper for this conference forthcoming in the Indian Journal of International Economic Law, published through Bangalore, which updates our Clue Arbitration blog last year and expands that. Dr. Ubilava has passed her PhD thesis with flying colours this year, and parts of that thesis I've already cited are published or forthcoming, as you can see here. And Dr. Ubilava and I have published also a book on a chapter in my book edited on new frontiers in Asia Pacific international arbitration and dispute resolution, which you can find here also online through ssrn.com in manuscript form. There is also in my book an excellent chapter on India, including econometric analysis of India's treaties and their positive impact on inbound investment into India before these changes to the model BIT and new strategy of India. That's by JNU Professor Jaivir Singh, which I commend to you. He also discusses a number of the more recent inbound claims against India. And lastly, an excellent paper I mentioned here by my co-author and presenter today, Professor James Claxton, looking at Asian treaties in particular and the types of references they have to mediation, which are mainly voluntary, require separate consent, whereas what we're proposing here is advanced consent in a treaty that before you go to mediation, the host state, for example, can require the investor to try mediation before progressing to arbitration in order to reduce costs and delays and stress in trying to resolve investment disputes. So thank you very much for your attention, and I look forward to any questions and discussion.